have to appeal, it means you didn't win. But if you have that unfortunate circumstance, you do want to hire them.
Good morning. Good afternoon. What a panel, and this is going to be a hard act to follow. I'm not a big speaker. You know, when I go to the Court of Appeal, they give me 5 or 10 minutes, 15 if I'm lucky, and I have to stick to that schedule. They stop me. So I consider myself the janitor of the legal profession. You know, the trial lawyers do this work, and then I get to clean up after them. And one thing I get to hear is what clients say about their attorneys, and I see the mistakes that the attorneys make. And I have seen them over 34 years. So what I did, shameless promotion, is I wrote a book. And this is my gift to trial lawyers, and I'm going to even reduce it down to plaintiffs' attorneys, because I don't do much defense work at all. I love plaintiffs' cases. So this book says, this is what you have to do to protect the case before I get on the scene. Because even in the last couple of months, I've turned down millions of dollars worth of appeals because I said, you blew it. So that's what I'm here for. So what I have, a lot of technical stuff up here. I took the 10 points from my book. I have 204 strategic tools or tips, and I took 10 just randomly. Now this isn't like a movie trailer where you go, oh, she's giving us her best tips. I don't need to buy the book and I don't need to listen further. This is just to kind of whet your interest. And it's at random, so if somebody stops me, I don't have a schedule, I'm okay. First tip, the trial lawyer creates the record. So the client comes to you with, I'd say, like a bundle of facts, and it's your job to take those facts, come up with a trial strategy, and tell a story. My job is I have to take your story that you told and work with it on appeal. I can't throw in new facts. I can't come up with a new theory. This is all up to you. And a lot of times, this happens before I'm ever called. So this is your job. And one thing, when I've given these seminars, and I'm not going to do it today because it's kind of embarrassing, I'll say to trial lawyers, tell me the 3 major standards of review. This is how the Court of Appeal will look at the appeal. You know what? Most of you can't tell me. You can't tell me what the standard of review is. And I'm thinking, how do you try a case, and how do you protect that record when you don't know how the Court of Appeal is going to look at it? So that's something you need to always know. Okay, second point. Appellate attorneys do not simply recycle the work of the trial lawyer. This is what happens, is I get a call and the trial attorney says, I just lost, I'm going up on appeal. I'll make it easy for you. This should be really cheap, which I never like to hear. And they say, I've done the trial brief, I've done motions, post-trial motions. Just take them and dump them into your appeal. And I say, no, I can't do that, because that's not what the Court of Appeal wants to see. It's an entirely different audience, and you're looking for judicial error. So I can't take your trial brief and use it. I may use parts of it, may help me with some research, but that's not how it's going to happen when I do the appeal. Now, I know trial lawyers who do their own appeals. They will do that. They will recycle their post-trial motions or trial briefs. And another thing they'll do, and I can tell you the Court of Appeal hates it, is they get up there and they argue as if they're in front of a jury. You can't do that, because the focus, judicial error, this is an intellectual exercise. Nobody wants to hear your impassioned plea, and they really take offense to it. So they love having appellate attorneys that stick to the law and the facts and aren't doing an appeal to the jury. Okay, it's the appellant's burden to produce a meaningful record. If you're going up on appeal as the appellant, you have to create the record, and then you have to designate enough of it so it shows an error. That's your burden, not just the error, but prejudice. If you're the respondent, well, you have to produce enough of the record that it shows that no error occurred or there's no prejudice. So you have to keep that in mind when you go into a judge's chambers or sidebar and you say, I don't need that court reporter. Well, yes, you do, because if it isn't in the record, it didn't happen. Okay, memorize the first rule of appellate procedure. Issues generally cannot be raised for the first time on appeal. And this goes to some very basic things like objections. If you don't make the objection, it didn't happen, and you've waived that. And that happens a lot, and I read transcripts, and I'll tell the trial attorney, I said, did you object to this? And the attorney says, oh, I'm sure I did. And I'll look at the transcript, and I said, no, that's not an objection. And don't get lazy because you're in front of a judge that you know, and you say objection, and everybody in the room knows what you're objecting to, so you don't have to specify the grounds. Yes, you do, because you're going up on appeal, and those justices aren't there. And don't object on one ground and think you can go up on appeal on a different ground because you've waived it. So you want everything, if you try the case down below on one theory, you're not going up on appeal and saying, I like this theory, I think this one will work better. And that you're stuck with that theory. So there's only a few exceptions to this rule, and that would be, let's see, where you have a legal issue based on uncontroverted facts, and there's no factual determinations. And the court will consider, say, maybe public policy arguments or constitutional arguments, but generally you have to raise it below. Okay, don't forget to make an offer of proof if the trial court is inclined to exclude your evidence. When you do the offer of proof, you're not doing it just for the trial judge. You're doing it for the Court of Appeal, because if the evidence doesn't come in, what does the Court of Appeal know? So you have to talk about the witness, what the testimony will be, the purpose, and the relevance. And that's to create a picture for the Court of Appeal. Okay, this is a common error. Appeal from the judgment of dismissal and not the order sustaining the demur without leave to amend. I see this happen quite a bit where you've lost that demur, it's sustained without leave to amend. Damn it, I'm going to appeal right now. You file that notice of appeal, but you don't have a judgment. You're waiting for the judgment of dismissal. And sometimes attorneys get a little creative, like they'll have the order and the judgment combined. So look at the order, make sure it's not also a little judgment in there, so you know what your timing is. Same thing for a motion for summary judgment. You don't appeal from the order granting the summary judgment, you appeal from the judgment. This is one that a lot of attorneys don't know. Consider a motion for new trial after an order on the motion for summary judgment. The reasoning is, well, there's no trial. Why would I do a motion for new trial? Well, it's dispositive. You can do it. I've done it, and sometimes I've prevailed on them, probably not very often. And you can also do it for demurs and motions for judgment on the pleadings. So sometimes it can work, and sometimes you want to do it just to beef up your record that is going to the Court of Appeal. This one's very important. I could talk about this and give examples. Understand that your words may be read by others not present at trial. You are not just trying this case for the jury and the judge, but maybe for the Court of Appeal. So make sure your words are clear, and sometimes read your own transcripts, because sometimes you look at it and you say, I didn't even complete the sentence. I don't know what I was saying. But I'm talking about things where you say, you have the witness pointing to something, you are, what about this, what about that? And you're talking about exhibits. Are we on exhibit number 1 or on 3? And then I don't know what you're on. I don't know what exhibit we're talking about. So think about this as like a radio show where not only are you trying the case in front of people, but there's somebody listening, and that person is saying what happened at that trial. I think I'm a little nervous, you know, after these trial lawyers, they sound so great. And know the rules of statements of decisions. This is an area, lots of errors. You don't just request a statement of decision. You can make proposals to it, but you have to object if it's wrong on the facts of the law. So just, if you do the request and nothing else, you don't object, it's as if it never happened. And you want to be able to do that. Last point, another error, lots of errors in this, object to an erroneous verdict form. I'm talking about special verdict forms generally, because they're so confusing. And I think what happens is the attorneys get together with the judge and they start formulating a verdict form for lay people, but they're not lay people. So take your special verdict form, give it to someone who's a lay person, and say, does this make sense? And if that person says, I'm a little confused about what to do, then change it. So, but you have to object or you waive that objection. So those are, did I make it?
You sure did. I sure learned
Boom,
something.
boom, boom, 10 minutes, that's, you know, in the Court of Appeal, they'll say, your time is up, but okay, finish your sentence and then get off.
Are there any questions?
I have a question. What are the 3 standards of review?
Oh, you have to buy the book.
That's why I had to hear you speak. We didn't charge you.
The 3 standards of review would be legal error, de novo, or independent review, like your motion for summary judgment or demur. Abuse of discretion, like letting in evidence, keeping it out, and substantial evidence. And let's say appeals, you have a 15 to 25% chance of success. Within that, you have different levels of success according to your standards of review. So if somebody comes to me with legal error, especially one that stops a trial, like a motion for summary judgment, I'm happy. If they come to me with abuse of discretion, I'm a little less happy. If they say substantial evidence, I go, oh boy. Because there usually is some evidence, and the way they call it substantial is not true. It's some reasonable evidence, and usually the other side has it, so those are often losers.
There's a question over here.
Just one quick question. What was your best advice on the oral argument? Be as boring as possible, or?
Is that a reflection of how I just talked?
No, not at all. You mentioned something about, don't argue like you're arguing.
Oh, how you,
Right.
well, they've read the briefs, and they'll tell you that, and sometimes the justices will get really prickly and say, we've heard this before. I try to find something new to say. I know my courts, and I use humor because it helps relax me. And, if I say something new, then they might perk up. I concede when it's necessary. I always answer questions. That's a big thing. They hate it when they ask a question and you go, I'll get to that. No, you answer that question right away. And then I have an approach where, let's say that my brief is so heavy with law that I don't want to talk about law when I get up there. I want to talk about the facts, and I want them to make the right decision. But then because I'm in appellate court, I say not only do you look at the person or my client, but you also have to consider how your decision is going to impact the public. So there's two-pronged approach, and I think, the attorneys have talked about that today, saying, do you focus on the client? Do you focus on people? And I'm convinced that most Court of Appeal justices, they want to come up with a just decision. They may want to make a difference in society by publishing cases versus just doing, case after case. And you just have to show them this is the right thing to do. Anything else?
Yeah, Donna? I'll just say I've read your book and I think it's great. I've done 2 motions for new trial, one after demur, and then one after a motion for summary judgment. They were denied, but they were good because it had a chance to test my argument again. And when the defense didn't really refute it and the court didn't really come up with what I thought was a strong justification, it was a stronger message to me that the appeal would be worthwhile. So even though the motions for new trial were denied, it was still a good test at the trial court level. And then the third motion was analogous motion in the federal courts. And actually, the federal court did reverse a summary judgment motion in part.
Oh,
So,
great.
you know, it's good stuff.
Yeah, why don't you hold up your book one more time?
I have a few in back, and
Yeah,
you can order them.
It's called An Appeal to Reason.
So, thank you for having me.
Thank you very much. Okay, we're going to go next to Paulette Taylor because Paulette's a trial consultant. I understand she's in trial. So after that, we will then go to Eric Goldman and then Paulette. Paulette is with Associates, who's got 20 years